to segment 7.5. I'm in the textbook on page 308. And this was a section in which you looked at potential monetization avenues that may be explored. First question that I have is, if one engages in monetization alternatives, such as out-of-court resolution or patent brokerage, does this increase or decrease the image of potentially being a patent troll? The reality is, if you litigate patents or you assert patents, which may include out-of-court resolution, both of those actions would be construed in today's market as being a patent troll. Now, if you went back 10, 12 years ago, anybody that would assert a patent, whether that is through litigation or out-of-court type resolution, you know, it was a gamble. Sometimes they were called patent trolls, sometimes they weren't. But it was a much more prevalent feature that was simply occurring in the marketplace. Nowadays, anybody that asserts patents, whether that's a school or an entity that doesn't have any other products, they just have intellectual property that they're licensing, the likelihood is that they will be construed or at least termed a patent troll. Now, what's interesting is that this is a little bit of a changing market. Not only that, but it's a little bit of a forked tongue. And what I mean by that is some of the companies, let's say Samsung, Apple, Google, a lot of those companies, whenever they go ahead and assert patents, you do not necessarily hear patent rhetoric indicating that they are a patent troll. But the funny part is that some of the technology that they are suing on is not even necessarily technology that has made it into products that they have created at the end of the day. It may have been products that they had acquired from a defunct company, and they are just simply holding the rights to that IP. So to a certain extent, we use it, that term, at least the market uses that term to characterize anybody that asserts patents, but for large companies that are creating real products, often it is not applied to them as much, despite the fact that they may still be asserting patents. Now, the exception there is patent brokerage, because if you simply try to sell your patents through a patent broker, often you will not be labeled as much as a patent troll, and that's simply because it's a more inoffensive type way in which you may be marketing the technology or the patent portfolio. The second question I have there is, how do patent brokers get paid? Now, that's a very good question, because everybody wants to get paid in some manner. So if you go ahead and if you go to a litigation team, and the litigation team is actually proceeding forward on your behalf, the understanding is that they often either are charging you on an hourly basis in which you are funding them out of your own pocket, or two, they are operating on a contingency basis, which if they are operating on a contingency, any money that comes through the door once, for example, resolution occurs, often will be diverted first to the litigators, and then it will come back to the inventors. And that is similar to a patent brokerage type model as well. If they go ahead and sell your patents, often there is a percentage of the proceeds that would be going directly back to the patent broker, and then the rest would then be funneled back to the inventor. So it would be a similar type model. Let's talk about some of these monetization avenues. So first off, the very first question that I say, if you are interested in monetizing, is infringement shown? Now, the question you'll be asking is, well, how is infringement being shown? And that would be going back to our last lecture, Rule 11 charts. So have you been able to show that infringement is actually occurring? And if the answer is no, then you need to go back and first do Rule 11 charts to establish whether or not infringement is even occurring in the marketplace. Because if it's not occurring, then there's no options for monetization, at least of a viable outcome that's usually consistent with what it is the inventor wants to get as far as money. But if there is infringement and you are showing it via claim charts in a clear manner, then there are a few different options. You can go down the litigation route, which we'll discuss, brokerage route, or potentially licensing, which is often construed as an out-of-court resolution type process. The claim charts, the Rule 11 claim charts, really provide the basis for all of this, because it gives us an objective basis to determine what is actually actionable. If the market hasn't even caught up to the invention yet, then the demand may be very little. And if the demand is little, then the value, in like manner, may also be very little. And this is consistent, for example, when we look at how it is before the valuation formula that we were looking at, intrinsic quality plus, for example, extrinsic demand, and the demand amount or value itself equals some type of valuation of the portfolio. And so when you look at it from that point of view, I purposely in the last lecture did not necessarily give you a set amount by which you can actually quantify the value. Because again, how it is that we go through the process of determining whether or not the intrinsic quality is satisfied, and this could either one be on a ranking score of a percentage, 100% being absolutely flawless, and 0% meaning that you don't want to touch it with a 10-foot pole. And there may be some ranking score within that where you are objectively as possible indicating how clear are the claims, what's the scope, what was the communication between applicant, any issues noted. And the more issues that are noted, the more that percentage may go down. When you get to the demand, then you can actually start looking at how much, from a damages point of view, is being reaped off of the infringement. And what I mean by that is, let's say that you have a patent on the tables that we were looking at, and the tables in particular that we had mapped via that Rule 11 chart, they've had in excess of $50 million in sales this year. It's a very extremely popular table. And so as far as calculating the value of the portfolio, an easy way would be to simply look at the patents, and let's assume for purposes of our argument that they were flawless. Intrinsically, there were no issues to the surface whatsoever. So we give them a value of 100%. We go on to the demand and we've charted it, and we say this charted correlation corresponds with, at a minimum, $50 million of profit that this company has enjoyed. So 100% times 50 million damages that would be, or at least revenue that has been achieved based off of the infringement, you would conclude that at a minimum, that value of the portfolio would be at least $50 million. When we get to the monetization avenues, those charts in the intrinsic versus extrinsic type analysis allow us to then look at what our options are, but we can have that figure in mind looking at how it is the damages have been formulated. The more objective we can be, the more it is presented less as a subjective type analysis, and that would be obvious, but that allows it for a person that's viewing this and looking at it to really look at it from the point of view of where is the value in this and how does it relate to my company. You'll notice that I have a bubble here with respect to strategic prosecution. Strategic prosecution includes actions relating to pre-grant prosecution. So you have the process, obviously brokerage, licensing, litigation is all dependent on having actionable assets, which in short includes granted patent assets. But prior to actually getting granted patent assets, you obviously have pending assets. And what you can do is engage in what's called strategic prosecution. That is, while you're going through the prosecution process itself, you may nonetheless still be creating Rule 11 charts. And this ensures that any modification that you're making to the claim is mapped to, for example, what is actually occurring in the marketplace. So it's a one-to-one type mapping, makes your Claim 11 chart a lot more squeaky clean when you are actually later on trying to map what is actually going on. So strategic prosecution is essentially application of Rule 11 charts while prosecution is going on. Litigation, licensing, brokerage occurs after you actually have granted patents. So the claim charts themselves, the strategy is to apply the strategy to real market conditions as we have discussed. Now from an ethics point of view, we want to satisfy and exceed minimum tests of infringement. I call them, and they are frequently called Rule 11 claim charts, because when you file a patent complaint within the federal courts, one of the things you need to satisfy is Federal Rules of Civil Procedure, Rule 11. And that is where you have a basis for the complaint that is being filed. That basis is why it is that we call them Rule 11 charts, because the basis is being shown by this potential mapping of the claim limitations and the potentially infringing product and or subject matter. Now, how do you actually analyze the target technology? Let's dig a little bit into this, because this will set the basis to understanding how it is that we actually present portfolios, whether it's on a litigation, licensing, or brokerage type map. And so when we analyze the target technology, we are looking at obviously mapping up specific products to, for example, the limitations of claims. And we're matching the claims to the product themselves. When we amend the claims, that's again looking at pending type assets. We do that usually and from your point of view, you may be saying, well, why would you ever do Rule 11 type charts when you're pending? Because the presumption is that if you apply for a patent and suddenly you're mapping it to something in the marketplace, isn't that a high likelihood of potentially invalidating your patent? Namely, that the marketplace product may have existed prior to your priority date. And the implicit assumption here is that you're doing that mapping some years after the initial filing. So there may have been the initial filing, a few continuations in place. At that 10-year mark is when you start getting the strategic prosecution involved, where you're actually doing the mapping during that pending phase. So how do we actually put this all together as far as the claim charts are concerned? You have the claim charts that go into a portfolio document with all the other analysis information relating to the portfolio, the number of assets that are involved, the length of the pendency of the patent term, so they get an idea as to how much longer it is within the patent term. And not only that, but you also look at other considerations such as whether or not there's any prior licenses, whether or not there's any encumbrances. So the owner may have previously licensed their technology to a different competitor. That competitor may now already have a license on that specific portfolio. So all this goes packaged together and is then presented usually in a licensing or out-of-court type assertion. For litigation, it's usually just the Rule 11 charts that are being provided in combination with the complaint that is actually filed. Now, as far as litigation, there are some considerations for you to keep in mind. I indicated earlier, the litigation can be very expensive, and it is. So, and actually to that effect, let's look specifically at the cost. First off, you can see that I have a breakdown here between 2005 and 2011, and some of the expected average median costs of actually going through the litigation process, all the way from the start of the process to, for example, end of discovery. And this is with respect to the amount in dispute. So if it's under $1 million, if it's up to 25, or if it's some unicorn type assertion where it's over $25 million. And you can see the amounts in dispute here may range anywhere from, if it's under $1 million, it literally may occupy over 65% of any recovery just in litigation costs alone. Where if you contrast that with if over $25 million is in dispute, it may reduce down to maybe 25% as far as total amount that is being expended. That's one of the reasons why it is the small inventors often cannot compete, because they cannot front the costs necessary to actually go ahead and recoup, let's say $650,000, or put up $650,000 in order to finance litigation to only get, at the end of the day, about $1 million worth of recovery. That is why contingency attorneys are often very it's needed for these small inventors so that they can still compete in the marketplace and assert rights relating to the litigation. Now, when you actually litigate, there's a few different options you can do. Let's assume you are the owner and you want to assert the patents. You can, on one hand, go ahead and assert them yourselves, and that would be a typical type route. On the other hand, you may not be interested in being labeled as a patent troll, so you may transfer the assets to a different entity that in essence sues on your behalf. And that is often what some companies will do as well. They'll transfer it to another entity that then sues for them, and behind the scenes the original company may be getting some royalty rate or royalty share based off whatever proceeds are recognized through that assertion type process. Last but not least, I indicated as far as some different questions relating to litigation. Do you have the money? We've already discussed that. Do you know where to file? Now, in today's market, you may file in Texas, Delaware. You can file literally in any venue across the United States. But each venue has different expertise as far as patents are concerned. So Delaware for a time was known as the Rocket Docket. Texas in particular had a Rocket Docket for a long time, the Eastern District of Texas. The up and coming venue right now is actually the Western District of Texas, which for many years did not do a lot of patent cases, but is kind of the emerging market now. Last but not least, but I indicate, can you play the waiting game? If you're an established corporation, often you can play the waiting game. And what I mean by that is, if you sue on infringement, you still need to often pay the attorneys in the short term. And that is where, if you're an established corporation, you can set aside budget to actually pursue going after the infringement and actually showing it. But if you're a startup, you often cannot weather the storm for the next 3-4 years while you're going through the litigation process. An established corporation can, but if you're a startup, you often cannot. And that is why often the smaller the entity, the more they are stopped from being able to participate in the assertion type process, because they cannot fund costs for the next few years while this is going through the litigation process, where they may eventually recognize some revenue associated with the assertion. So from that point of view, again, having contingency options in place for startups and small inventors would allow them to more fully participate with actually overcoming that waiting game deficiency gap. Now I have here, for example, an example of an actual complaint showing that this was the dispute between Apple and Samsung. On the left-hand side, you can see that Apple goes through and indicates what it is they have patented. They also list the exact patents that are the basis for the assertion that is being included within the complaint. So you can see specifically that on the right-hand side, there's another page there of the patents that are specifically being included. And so when you file this complaint, you are very specific in not only indicating what is the basis for it, but often in that complaint as well, you will include some rationale for why it is that they are potentially infringing those patents. And even in today's market, sometimes I see in initial complaints, a Rule 11 chart will even be included in it to show that there is more than a reasonable basis for the correlation between the potential infringement and the limitations of the protected claim set. So that is with respect to litigation type considerations. When we look at brokerage, I would indicate that the preparation that would go into litigation, namely the Rule 11 charts, fleshing out the details, all that is literally identical for brokerage type routes. The only difference is you're not going before the court to try to resolve the dispute, and you're simply going through almost a neutral party broker who then on your behalf goes and then operates before companies to try to sell. So you could go to door yourself, and some companies and inventors will do that. The likelihood is that you may not really achieve a lot of success in doing that. There's a reason why there are patent brokers in the market, namely, they often already have connections within each of these companies that allow them to get their foot in the door, to then present portfolios for review by the specific company. Brokers in particular assisted with sometimes patent auctions, and there's two examples I have here. The Nortel sale of their portfolio for $4.5 billion, that included 6,000 patents. Motorola, again, for 12.5, and that included 24,000 patents. So you can see that there can be extreme numbers of patents that are being sold in relation to some of these sales that, again, are being brokered by patent brokers. Licensing is a little bit of a different approach. Again, as far as the preparation and the difference between litigation brokerage and licensing, there really is almost no difference. You should still go through the robust analysis. You should still prepare Rule 11 charts. Again, for licensing or out-of-court type negotiations, you are not going before the court for resolution, in which case you literally are approaching the companies. In a patent broker context, what they're doing is approaching them for the point of view of selling the portfolio to them. For a licensing, they would be approaching, patent brokers sometimes do this, or other outfits, and they would approach them for the purposes of licensing the portfolio to that intended company. Now, under this type of approach, you may be asking, well, is it actually worth it? I cited Qualcomm earlier as far as having different revenue streams, but they are known to make almost $11 billion annually off of licensing. That's an enormous amount, but it's a very viable revenue stream for them. It takes a lot of time and energy, I imagine, for them to actually get to that amount, because they have to approach companies individually and say, hey, I think our portfolio is applicable to your company. They often will then approach the company and actually present a number of presentations to show the mapping based off of, in essence, Rule 11 type charts. There's some negotiation. Often they will go back. Probably the other side may put forth some of their own patents to try to lower that license fee amount. And then there may be some agreement in the results. Another question is, can I license without suing? And the answer is, often the answer is yes. You can license without suing. Will it be as effective? Maybe not. And for example, there are some companies in the past that I've seen where you may approach them to license a portfolio, and they say, you know what? You didn't hear this from me, but this portfolio does have probably a lot of applicability to the company. Now, they would never admit that, but between the lines, they may in fact be saying that. But I have in fact heard where they would say, I cannot prioritize your portfolio based off of what it is that you're currently doing, namely out-of-court type licensing. And they may respond and said, can you please go ahead and file an actual complaint in the courts, which internally in my company would prioritize the action that I can then take to actually resolve this. So some companies have internal procedures such that they cannot, or not as quickly, resolve issues unless formal action is taken within the courts. And if that's the case, then that's just on a case-by-case basis, where some companies have that procedure and policy. You know that, you go ahead and respond accordingly in order to get to the resolution. Other companies don't have that policy. And so their policy may be, we are open to negotiating with you in an out-of-court type manner to keep the cost down. Other companies, for example, Nintendo or Newegg or other companies that just have a reputation out there, where if you approach them in a licensing type manner, 99.9% of the time, they will simply come back and say, we are not interested. You can even sue us in the court, and we are still not interested. And one of the reasons for that is they were hit so much with patent assertions in the past that they took a policy stance that if you assert patents against us, we will not settle. We will fight this literally to the death. We will take you to court. We will fight all the way to a jury, and whatever the jury decides is what the jury decides. But we will not settle prior to essentially a jury determination. Next question is, can I license without brokering? And the answer to that is, of course you can. But your ability to actually get to the end goal may actually be stunted. Brokers have contacts, and it's those contacts you need often for licensing type initiatives. There are companies out there that will literally just assist with out-of-court type licensing. I'm aware of a few, but what they really do is they go out on your behalf or the owner's behalf, and they will contact these companies and say, you know what, here's a Rule 11 chart. We feel that there's some applicability to your company. We would like to resolve this in an out-of-court type manner. Please contact us to get to a resolution on this manner. So there are companies that will actually do that. If you actually go through some other company, one of the points I make here is that you may still want to engage in licensing considerations so that you retain some type of a license. And what I mean by that is if you go ahead and either license or seek to license yourself or through another company, if you are still using the invention, you may want to retain some ownership right, or at least some ability to still use the invention for your company. And that's usually what's called a grant back type license, where you may transfer the assets to another entity that is then asserting, and that entity will grant back a license back to the original owner so that they can still make use or sell the patented invention. Types of licenses that you see out there are open standards, royalty license, strict license, out-of-the-box license. There's also a carrot license. Anyways, there's a lot of different licenses that can relate to when you are actually licensing a portfolio. I would say the more common approach is just a one-time sum license that is for all considerations. And what I mean by that is, rather than having a piecemeal type license where you say, we'll pay you $5,000 a year for the next 20 years for use of your license or for use of your patent, you may simply say, I want to sell now for a one-time lump payment of $80,000 for a license to your portfolio without end. And so the more common, I say, would be a one-time type lump license, and that would be more common with respect to licensing type alternative, or even if you went down a litigation alternative. So if you went down litigation, you go before a jury and there's some final determination at the end of the day, what may result is in fact a license between the owner and the company that is infringing. And that license often is a one-time lump payment sum that grants them a license for use of the patents.